Okie dokie. This one here, consider it letting off some warning rounds, and we're going to compare two videos, and that's what helped me come to this conclusion. Now, not long ago, made one of the longest videos we've ever uploaded, and we get a expert, Professor Pokington, to go through an article from the Advertiser about reforms to pokey laws and changes to the machines, and for non-Australians that's the slot machines. Now, amongst the talking points and justifications for these counterproductive reforms and changes, like making the machines accept notes instead of just coins, which are just ultimately gonna shovel more money into the hands of the aristocrats, and I shit you not, that is the name of the company that makes the machines. Couldn't make this shit up. So amongst the reasoning for why South Australia's going ahead with all that, somebody said, we will be in line with the other states. We will be up to date with the rest of the country. Now keep that in mind while we go further back in time to June, when I did a video for Pride Month, which I covered the history of the fight for their rights from back to the Stonewall riots to when Australia made same-sex marriage legal. And that is how I first came to learn about the gay panic defense. Now, to arm you with all the necessary information, we will go through some of the history of this defense in Australian law, and we'll use this Vice article. Gay panic was the colloquial name for the Section 304 of Queensland's Criminal Code. There were once similar laws all around Australia, however, state by state, these were swept away by reform or direct repeal, beginning with Tasmania in 2003. As archaic as the defence seems, it was only enshrined in national law in 1997 after the death of Donald Gillis in the small Victorian town of Mudgee. Gillis's death at the hands of one of his best friends, Malcolm Green, was brutal. He was first punched 35 times before being stabbed 10 times with a pair of scissors. Finally, 22-year-old Green slammed Gillis's head into a wall repeatedly. The pair had known one another for at least 6 years. During the first trial, Green argued his friend made an ominous advance after a night of drinking, slipping into bed beside him in a spare room of Gillis's house. "Yeah, I killed him, but he did worse to me," Green had told police at Mudgee Police Station. "He tried to root me." While Green was initially found guilty, he appealed his case all the way to the High Court of Australia. In 1997, the court sided with Green that evidence of the sexual abuse of his sister by their father should have been provided to the jury in his original trial. His murder conviction was overturned. 2 of the 5 judges dissented, including Justice Michael Kirby, Australia's first openly gay judge, who addressed the concerns that limiting revocation as a defence would affect women who are abused and fight back. Early in the morning of July 4th, 2008, a parishioner on their way to church found the lifeless body of Wayne Rooks inside the grounds of St Mary's in Maryborough, Queensland. It would soon emerge that Rooks had been bashed to death by 2 men, Jason Andrew Pearce, 36, and Richard John Meerdink, 39. During the investigation and subsequent trial, an explanation was floated. Rooks had made an homosexual advance towards Pearce as the two sat down on a park bench in the churchyard to smoke a joint. Pearce, who had been abused as a child, snapped. That this could even be a defence came back to Queensland's controversial gay panic law. The loophole meant a non-violent homosexual advance could be grounds for a murder charge to be downgraded to manslaughter. The move to repeal gay panic in Queensland came after a 5-year-long campaign by Father Paul Kelly, sparked by the death of Wayne Rooks. Father Kelly was the priest at St Mary's, the church where Rooks was killed. Since it was launched in 2012, his Change.org petition to change the laws has amassed nearly 300,000 signatures. I am so enormously grateful that this law has been abolished. A clear message has been sent that all people are equally deserving of protection under the law. irrespective of gender or sexuality, Father Kelly told Vice. It tells the community that it is not a mitigating factor for extreme violence that somebody made a pass at them, either real or imagined. The law has unambiguously rejected any implications that sexuality is an excuse for intolerance, violence, and bigotry. In Queensland, the gay panic defence could be applied when one person killed another in the heat of passion caused by a sudden provocation and before there is time for the person's passionate to cool. Successfully argued it could see a murder charge downgraded to manslaughter, which is what happened in the trial of Pierce and Meerdink. In 2009, the pair were both found not guilty of murdering Wayne Rux. A jury convicted Meerdink on a lesser charge of manslaughter. As a seriously violent offender, he must spend at least 8 years in jail. Pierce, on the other hand, who had pleaded guilty to manslaughter, walked free in 2012. Paris told police Rooks had grabbed his penis when they sat on the bench. Later in prison, revealed to a police officer that he had snapped because he was sexually abused by a school janitor when he was 6 years old. The judge ruled that it was impossible to tell whether the advance had actually occurred. It couldn't be seen on the CCTV footage. It's also unknown whether Pierce or Meerdink landed the fatal blow. On the night of the attack, both men had kicked and punched Rooks during a beating that stretched out more than 6 minutes. What is known is that Rooks was beaten so badly that he died from internal bleeding after the pair had left him in the churchyard. While Queensland may have closed the gay panic loophole, save for exceptional circumstances to be decided by a judge, the defence is still on the books in one final state, South Australia. Last year, the retrial of Michael Lindsay sparked a fresh debate about why it remains as a partial defence in SA. Lindsay, who invoked the gay panic defence, was twice found guilty of the 2011 murder of Andrew Niger before being granted a retrial by the High Court. During his original trials, Lindsay had argued Niger provoked him into the killing after repeated unwanted advances, but the prosecutor painted a different picture, saying the victim had made some sort of sexual connotation, something like, "I will pay you for sex." Lindsay responded by beating and stabbing Niger until his co-accused, Luke James Hutchins, took the knife off of him and cut Niger's throat. In September 2016, Lindsay was sentenced to life in prison after his retrial. Since the verdict, there has been very little talk from politicians in the state about ending the gay panic defence in Australia once and for all. Alright, can you kind of see where I'm coming from here? I, as a South Australian, would prefer that we catch up with the rest of the country when it comes to our laws and using pretty much just straight up homophobia as a defence being abolished. I'd much rather catch up with the rest of the country with that rather than whether our poker machines can accept notes. But let's move on and see what has been done, if anything. From a BuzzFeed article titled, "This is why South Australia still has the gay panic defence." Here's just a couple of short paragraphs. Under the partial defence, widely referred to as the gay panic defence, people accused of murder can have their charges downgraded to manslaughter if they can prove their victim made a non-violent gay advance. The defence has become part of common law, meaning it is not from legislation but precedents set over time by judicial rulings. South Australian Premier Jay Weatherill pledged to end the gay panic defence in May 2016, labelling it an outdated and offensive notion. The South Australian government says it's waiting on a report from the South Australian Law Reform Institution on the best way forward. So 2016, there was talk about getting rid of it, which was mentioned in an article I read that's from 2017. And I'm trying to be as fair as I can to these people. And it mentioned a report by the South Australian Law Reform Institute and how they're waiting for that to come out before they move forward. And yeah, I went and found it and had a look. Stage 1 came out in April 2017, Stage 2 came out in April 2018. Now, the excuse has been, beforehand it was the trial of Michael Lindsay, and they didn't want to do any reforms while there was a trial happening. And then the excuse was they're waiting for this report to come out to work out the best way to move forward. And yeah, I went through most of the first 150 pages of stage 1 and the 238 pages of stage 2. And there's some good recommendations in there and points out some problems that could arise, which mainly is if as they say, woman were to kill their partner in self-defense during a domestic violence attack, which really highlights something I've come to learn about society, which is they're all about trying to deal with something at the end of it rather than trying to address a problem before it becomes such a problem. The timeline of events kind of make me cut my Attorney General a little bit of slack, but also it makes it look a lot worse because we've had a change of government. Our Premier is no longer Jay Weatherill, we have Stephen Marshall, and Vicky Chapman became the Attorney General in 2018. Here's some quotes from an article by SBS titled "Essay to Remove Gay Panic Murder Defence" from the 5th of June 2018. "It is well past time that this defence be removed from our laws once and for all. Attorney General Vicky Chapman said it was simply no longer acceptable to allow gay panic as a defence and committed to changing the law." The report published by South Australian Law Reform Institute investigated whether repealing the provocation defence may have an adverse effect. Provocation laws can apply in other situations, including family violence scenarios, but the report found the current law was unfair to some victims. You don't say, "Oh, can't do anything until we have this report." And then the report comes out and says, "Oh, we can't do much because of what the report says." No, it's been far too long. So then all of 2018, I would have allowed as a reasonable amount of time to draft the legislation. But then 2019, trying to get credit when you're saying during a milestone anniversary of the Stonewall riots that, yep, we're going to do it, give us a pat on the back, we're finally getting around to it, and then say it has to take you till the end of the year, which is now. And I've seen articles and reports saying that it should be happening by the start of 2020. Hence why this is letting off some warning rounds. 2 years after Queensland, 17 years after Tasmania, being the last state, and we still haven't dealt with this. Oh, and the one upside to being the last state to deal with this is I guess we have lots of other examples on how to go about it. We could look at New South Wales, or Tasmania, or Queensland. We could do what was said in those reports. And another thing about timelines, which I think is probably the most dangerous thing about it all, is Andrew in South Australia was punched, stabbed, and had his throat slit before he was dumped in a wheelie bin. 3 years after Wayne was found in the church, who, by the way, mothers said didn't even support same-sex marriage, so she was quite shocked to find out that this was how it went down. So it just goes to show that this law is absolute bullshit and just is hearsay and homophobia as a reason to get your charge downgraded. Like my housemate said, you don't get a little card identifying your sexuality, so how do you prove this? Gay panic defense has killed straight men. So yeah, back to the timeline and the publicity that may have come from Wayne's case and the priest who had to get 300,000 signatures. Maybe perhaps through that series of events it was found out that South Australia still hasn't done anything about it, and that's why that man lost his life in such a brutal way. Now what I'm trying to say is, if that defense wasn't a possibility, maybe he may not have been murdered, if that makes any sense. So I think it's just, other than offensive to still have this in the laws, it's dangerous. So I don't know, by mid 2020, if I don't see this finally dealt with, oh, and I will be keeping an eye out, I've bookmarked this site, then the South Australian government has got a lot to answer for. And is it really that hard to make some laws that make the distinction between murdering someone because you're a homophobe and a domestic violence victim killing as a result of self-defense? Like, Vicky, you could use some of those very impressive linguistic gymnastic skills you have that you use to cook up a beauty, like poker machines taking notes will reduce gambling related harm. If we got the aristocrats to ask you, would it become more of a priority? Alright, like, subscribe, see you next time.